Now today we study part 3 of the Indian Constitution, which is the fundamental rights. As we can see in the projected screen, the middle part 3, fundamental part 3 of the Indian Constitution contains rights that form the cornerstone of the Indian Constitution, and they are enforceable by courts of law, which means if your fundamental right is violated, you can approach the court. Okay, you can approach the court. This is what it means by enforceable by courts of law. So part 3 of the Indian Constitution covers article 12 to 35. Article 12 to 35. Now let's move on to the next. Today, here are the things that we will be learning today. This is the learning outcome of today's session. You will understand the meaning of fundamental rights, the meaning and significance. We will be studying the meaning and significance of fundamental rights in the Indian Constitution. You will also be able to classify rights. The classification of rights is given in your notes in the document. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational right, and right to constitutional remedies. And you will also understand the entire articles one by one, and you will also be able to distinguish between different types of rights. Okay, you will also be able to distinguish between fundamental rights from ordinary legal rights, and you will also understand the supremacy of fundamental rights over ordinary legal rights. And number 5, you will also be able to analyze important Supreme Court judgments related to fundamental rights, which we will discuss about today. And you will also be able to solve NPSC and SSB questions quite easily and with confidence once you're done with today's lectures. Let's begin with why fundamental rights is important. Please go through it one by one. I'll give you guys 30 seconds to go through it. As we can see, fundamental rights that guarantee liberty, equality, democracy, justice, dignity, individual development. Now just think about it. If you were to live in a country with no liberty, no freedom to do what you want, would you like to live in that country? A big no. If you live in a country where we're not equals to the majority of Indians in the mainland India, would you want to live in that country? No. Fundamental rights guarantees that everyone is equal before the law. If Modiji commits a crime, and if you commit a crime, the severity of your crime is the same as the severity of Modiji's crime. Okay, both of you will be dealt with by the law equally, and it also guarantees democracy. It guarantees justice, social, economic, and political. It also protects your dignity, and it also encourages individual development. Okay, these are the reasons why fundamental rights is important. Now, in your examination, if you are asked, give reasons why fundamental rights are important, you can give these 6 points. Okay, very good points: liberty, equality, democracy, justice, dignity, individual development, and you can elaborate on that. Now, if you look at the historical background of fundamental rights, the rights that we know now, right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational right, and right to constitutional remedies. These 6 rights, under which contain the different articles, that is the fundamental rights that we know today. But originally, the original idea of fundamental rights began in the year 1931 in the Karachi session of Indian National Congress. They proposed a list of fundamental rights, right to equality, right to freedom, and so forth. And that was the original proposal of fundamental rights for the Indian citizens, which was incorporated in the original Indian Constitution. The Indian Constitution came into force on 26 January 1950, and so the Karachi Resolution was included in the Indian Constitution. Okay, so we're talking about the historical background, what happened before the Constitution and during the enactment of the Indian Constitution in 1950. Fundamental rights became enforceable in 1950, and present day, at the moment right now, 6 fundamental rights remain. Okay, now back then we had right to property. In the original Indian Constitution of 1950, we had right to property as a fundamental right, but they removed it, and now right to property is an ordinary legal right under Article 300A of the Indian Constitution. It's not a fundamental right, but it is a constitutional right, but not a fundamental right. And we will also learn about what is fundamental rights and what is constitutional right later on. Here's the exam tip. It's one of the most favorite questions asked by NPSC. Which Amendment Act removed right to property from Part 3? They will ask you this question. And the answer is 44th Amendment Act. Okay? The 44th Amendment Act removed which fundamental right? Right to property. So they will twist the question. The answer is 44th Amendment Act 1978 removed right to property from Part 3 of the Indian Constitution. Okay? As we discussed earlier, why are these rights called fundamental? We're not talking about importance, okay? We are not talking about importance. We are talking about why the word fundamental. Fundamental rights. Because these are not needs, not wants. These rights are essential. They are not optional. They are a direct derivative of your natural right. Fundamental right is a direct derivation of your natural rights. So it's as close to natural rights as possible. Right to live is a natural right. It's as close to natural right. Fundamental rights are called fundamental because these rights are essential, not optional. You cannot live without these rights. These rights are essential. You look at individual development. Fundamental rights is called fundamental because it encourages individual development. It guarantees individual development. It is essential for intellectual, moral, spiritual development of every individual. And it also protects our dignity. As a human being, it protects our dignity. And one key point that you need to understand is without fundamental rights, democracy becomes meaningless. Okay? The ideals of democracy are guaranteed by the fundamental rights. And as a consequence of which, without fundamental rights, democracy becomes meaningless. Now, these are the salient features of fundamental rights. You can directly study from this PPT, okay? You can directly study from this PPT the salient features of fundamental rights. So what are the features of fundamental rights? Number one feature of fundamental rights is it's justiciable, which means you can go to court in case your fundamental rights is violated. Okay? You can go to court in case your fundamental rights is violated. Somebody violated your right to education, and somebody states that you do not have the right to educate yourself. You can go to the Supreme Court and you can fight against it. Somebody said, I don't have the right to education, but this is a fundamental right. I want the court to issue an order. So you can go to the court for the enforcement of fundamental rights. Okay? Next is not absolute. It is subject to reasonable restrictions imposed by the state in public interest. Not every fundamental right is absolute. Some are absolute, some are not. Why? For the interest of national security. Now imagine there's national emergency and there's Article 19 of the Indian Constitution. One of the fundamental rights is freedom of speech and expression. freedom of movement, freedom of residence, freedom of profession, freedom of assembly, freedom of association. Now imagine you forming an assembly at times of national emergency. Now let's say we have a war with China, right? It's very important for us to maintain internal security. And imagine a community forming an assembly, an association. It would not be right. Suspicions would arise. And who knows, right? Who knows? That particular community, what if they're pro-Chinese? What if they support the Chinese? So at such times, the government can put certain restrictions on the public, on the community, that you do not have the entire speech and expression, freedom of speech and expression. Your freedom of speech and expression sometimes can be taken away, can be limited at times of emergency for the sake of peace, for the sake of national security of the nation. So that is what it means by not absolute. Some rights are absolute, but some rights are not. Okay, it's a combination of both. Now it protects individuals against the state. It protects individuals against the state. And when you are being protected against the state, it means it's a negative right. There's a difference between negative and positive right. Positive right means state can get public ke protect kuribi ko ase. Positive means direct na state can get order dia ase protect kuribi. But then one state lahat probably protection lagi do in some cases, that is called negative right. So this is a negative right. Protection, protect us against the state. Okay, the state cannot do kushumushi towards us. So that's the meaning. And constitutionally guaranteed, which means it cannot be taken away from us the same way ordinary laws are taken away from us. Now there are lots of ordinary laws. Okay, there are lots of ordinary legal laws that the Indian Parliament makes, but it's different. Fundamental rights is different in the sense that it cannot be taken away very easily. Now, in order to take away the fundamental rights, we have the special majority, like I mentioned before. Special majority, 2/3 of the members present and voting should vote in favor of the removal of a particular part of the fundamental rights, plus 50% of the total membership of the House. And even if you were to pass a bill removing fundamental rights, what are the chances that the Supreme Court would accept it? Right? Fundamental rights, I've mentioned in our earlier lectures that the Supreme Court says that fundamental rights cannot be changed in such a way that it stops being a sovereign, democratic, and republic. The basic structure should always be maintained. So it's very difficult to take away your fundamental rights. Okay? Now ordinary rights, they create a lot of ordinary rights over time. They create a lot of your consumer rights, right? Your consumer rights, your income tax rights, okay? So, and so forth. These are ordinary rights. They can take away, they can make changes to it, they can do this and that. They'll increase the tax, they'll reduce the tax. And then consumer rights, they'll add in a clause saying that, you know, if a consumer consumes something that's hazardous to his health, then he is entitled to compensation, and so forth. They can make a lot of changes to ordinary laws, but fundamental rights is constitutionally guaranteed. It's very difficult to take away. Okay? Subject to reasonable restrictions. I mentioned that earlier. It's subject to reasonable restrictions, which is similar to not absolute. Okay? The state may impose restrictions that are reasonable and in public interest. Now, they are enforceable by court. Now, they are enforceable. The Supreme Court and the High Courts are the two courts that enforce fundamental rights. Now, the Indian Constitution has given power to the Indian Parliament to give power to any other court. Okay? But at the moment, right now, no change has been made, and it's only the Supreme Court and the High Court that enforces fundamental rights, not the District Court. Okay, just the Supreme Court and the High Court. These are the only two courts that enforces fundamental rights. So if your fundamental right is violated, you cannot go to the District Court. You should go to the High Court bench, Kohima, if it happens in Nagaland. Now in Article 12, if you look at the document that I provided to you, the definition of state. Okay, in the discussion of fundamental rights, the discussion of state, in the discussion of state means the government, the Parliament of India, all local authorities, and other authorities within the territory of India or under the government of India, which means when we're talking about the state, right, protection from the state, protection against the state, by state we mean authorities of the Indian government, any authority of the Indian government, okay? Like even the village council is a state in that particular instance. When we're talking about fundamental rights, we're talking about the citizen and the authorities. So authorities include everyone, and the citizen includes us that are not authorities. Okay. That's it. The definition of state in Article 12. In Article 13, judicial review. Judicial review is the process through which the Constitution is reviewed by the Supreme Court. Okay, judiciary can review करे, which is to say, if the Indian Parliament enacts a law that's against fundamental rights, the Supreme Court and the High Court has the power of judicial review to review against the laws passed by the Indian Parliament, especially the Supreme Court. The Supreme Court has the power to remove a law that's not constitutional. Okay. Now it's explicitly mentioned in the Indian Constitution. Since the Indian Constitution was created in the year 1950, it also talks about pre-constitution and post-constitution laws. Okay, it makes a declaration that India 1950 the Indian Constitution आया जे तो उतो Indian Constitution ला आगे दे कानून की थाकी से that are not consistent with fundamental rights remove कोडी से इना को आसे दा आरो what happens after आरो India Indian Constitution one adopt करे आसे ताकि पर की लुई जाबो बोले दो only those laws that are consistent with fundamental rights. It's a very simple declaration made in Article 13. Okay, it also gives the Supreme Court and the High Courts to protect fundamental rights. And then one Louis Jishe, Louis Jab Udo forever Supreme Court or High Court protect Kurubo. Koigina Article 13 de Diginase. It states that Purana laws that are not consistent with the fundamental rights have been removed, and whatever we have adopted, they are consistent with fundamental rights. And the Supreme Court and High Court has a power of judicial review to protect the fundamental rights. Okay? If the Parliament enacts any laws, they'll check, they'll review it. The judiciary will review it by the power of judicial review and see whether this is consistent with fundamental rights. If it goes against fundamental rights, the Supreme Court will directly strike down. And the Parliament, Indian Parliament, needs to listen to the Supreme Court. Okay, that's how fundamental rights is protected. Originally, we had 7 fundamental rights. The right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies, and right to property. Right to property was part of the fundamental rights, but it was removed by the 44th Amendment, which I mentioned earlier. I don't need to repeat it twice. So that's it. That's the original 7 fundamental rights. Now, presently, we have 6 rights. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. These are the 6 rights that we have in the present. Now, we have talked about Article 12 and 13, and we saw the present fundamental rights, Article 14 to Article 32, and let's take a look at Article 33 to Article 35. What does Article 33 say? Here you will, as you can see in the screen, Article 33, Parliament may modify fundamental rights for armed forces, police, intelligence agencies. Okay? Which means in order for armed forces to act freely, to act independently, they modify certain parts of the fundamental rights. Okay? They modify certain parts of the fundamental rights for people of armed forces, the police, and intelligence agencies. The parliament may modify fundamental rights if they get the same rights as the Indian citizens. It means they do not have special powers, right? And all of the puido kawo to do this. We know the ASPA Act, it provides immunity to the armed forces. And so if they go to, yes, we saw the consequence of ASPA Act, the Oting incident, right? But also at the same time, if there's no ASPA Act, then they will not have the courage, the confidence to take action. So there's good and then there's bad. Okay, but in today's world, the way that the state of Nagaland is, most of us, we advocate for ASPA to be removed, right? We do not like ASPA 8. But there's also another side of the coin, which means without ASPA 8, mundangar no hoy. So there are certain fundamental rights that are modified for the armed forces, the police, the intelligence agencies. That's all you need to know. And in Article 34, we have the restriction of fundamental rights during martial law. Again, during martial law, certain fundamental rights can be restricted, okay? During martial law, certain fundamental rights can be restricted. And Article 35, only Parliament can make laws regarding certain fundamental rights. It gives power to the Indian Parliament to make changes to fundamental rights. So Article 33 and 34 talks about the armed forces, the martial law, and so forth. And in Article 35, Article 33 and 34 is not for us. You just have to know that it's not for us. It's for the armed forces, right, and their martial law and so forth. Just know that Article 33 and 34, security-based article as it. And Article 35, Parliament get power there to make changes to fundamental rights. Now these are of the various fundamental rights that we have here in the document provided to you, Article 14 to Article 32. There are 5 rights. There are 5 articles available only to citizens. Article 15, 16, 19, 29, and 30. Okay, it's very important, very, very important. You need to know rights that are available only to Indian citizens. Article 15, 16, 19, 29, and 30. Foreigners cannot claim these rights. I've mentioned it here. Foreigners cannot claim these rights. But these are the fundamental rights that are available to all persons. We have Article 14, we have Article 20, 21, 21A, 22, 23 to 28. Everyone is equal before the law. It doesn't mean whether you're a citizen of India or not a citizen of India. And Article 22, protection in criminal convictions. If you're convicted as a criminal, then you also have the same rights as the citizens of India. And in Article 21, life and personal liberty, you also have the right to life, to live, even though you're not a citizen of India, and so forth. Okay, these are the fundamental rights available to all persons. Now, fundamental rights and human rights. Fundamental rights and human rights. Now, if you take a look at it, the Universal Declaration of Human Rights. These are rights declared by the United Nations, okay? United Nations General Assembly. It codifies some of the rights and freedoms of human beings. We have different rights, and of the different rights declared by the United Nations General Assembly, United Nations declared our rights there. We adopted some of these rights into our Indian Constitution. So United Nations declared one right, equality before law. Okay, we also copied that and then added it in Article 14. And United Nations has another human right, freedom of speech. It's also contained in Article 19 of the Indian Constitution. And the United Nations has another right, human dignity, right to human dignity, which again is contained in Article 21 of the Indian Constitution. So you might be asked about the correlation between the United Nations Universal Declaration of Human Rights and the fundamental rights. These are the 3 articles that you can use to help explain your answer, okay? The relation. Now we talked about whether a fundamental rights is absolute. No. Okay, fundamental rights is not absolute. Your freedom of speech sometimes can be taken away for the security of state. Your freedom of speech can be taken away for security of state. Your freedom of movement can be taken away to maintain public order, and your personal liberty can sometimes be taken away. Okay. Now, rights are not absolute. The parliament may impose reasonable restrictions. Restrictions must be fair and reasonable. Balance is maintained between liberty and social order. So they try to maintain the balance between our liberty and the social order that's needed for a country to be peaceful, to be secure. Okay? Exceptions. There are two articles that are absolute, which means it cannot be taken away at any point. It cannot be restricted at any point. These are Article 17 and Article 24. Article 17 being abolition of untouchability, and Article 24 protection of child labor. Okay, I'm sure all of you understand the meaning of untouchability. It's very common, okay, in the Hindu society. We have the Varna system, the Brahmana, Kshatriyas, Vaishyas and Shudras. The Shudras are considered untouchable. So if you touch the Shudras, you are considered unclean, and so forth. So these are, or we have another class, the Jantelas, which are almost similar to Shudras, but the lower class of the society that people generally consider untouchable. If you touch them, you're unclean. So Article 17 abolishes untouchability, and it prohibits the practice of untouchability. And Article 24, it protects children from child labor. Suspension of fundamental rights. When can your fundamental rights be taken away? Under what circumstance? As mentioned, this particular slide is to discuss about when your fundamental rights can be taken away. Now, at times of national emergency, for example, China attacked Korea, and we are at war with China, and the Indian government has declared an emergency, a nationwide emergency, and which is invoked by Article 352. We will learn about that later. Okay, Article 352 talks about national emergency, and so your Article 19 automatically gets suspended. What is Article 19? Please take a look at Article 19. Protection of 6 rights regarding freedom of speech, assembly, association, movement, residence, and profession. So at such a time, you do not have the freedom of speech. It will be restricted to a certain extent, and you might not have the freedom to assemble into groups. You might also not have the freedom to form associations. Not entire restriction, okay? Not entire restriction. It may be restricted. And your movement, right? You cannot move from one state to another. And if you move, then there will be government permit system or different kind of checking. And you will also not be allowed to reside in certain places. And you will also be restricted in terms of your profession, maybe at such a time. Okay, so certain restrictions may be introduced by the Indian government, but only during war or external aggression. There are two types, okay? There are two reasons why national emergency is declared: during war or during armed rebellion. Armed rebellion is an internal matter. Chutu-mutu jagade, for example, NSC and IM kan, right, and so forth. Yeah, the armed rebellion ekta hoise, but within the territory of India. And in such a situation, the Article 99 won't be submitted. It won't be suspended. But overall nation effect when it comes to war or external aggression. External aggression means India paharba, China or India kiliyase. That's a very big thing. So at such a time, Article 19 is suspended. Okay. But Article 20 and Article 21, protection in respect of conviction for offenses and protection of life and personal liberty. These two rights cannot be suspended under any circumstance after the 44th Constitutional Amendment Act. Okay? Now, let's discuss fundamental rights versus legal rights. I've explained earlier that just because a right is legal, it doesn't mean it's fundamental. Okay? Fundamental right is a legal right as well as fundamental right. Legal right means any right that's derived from the Indian Constitution, right? It could be a statute, which means a law passed by the Indian Parliament. It could be explicitly mentioned in the Indian Constitution, and it could also be a fundamental right. All these rights are legal rights. But what differentiates fundamental rights from the rest of the legal rights? Fundamental rights are constitutional. Okay, constitutional. Legal rights, they are created by ordinary law. They are created by ordinary law. Ordinary law, or any law that's not fundamental, is considered ordinary law. Okay, now they are directly enforceable. They are directly enforceable in the Supreme Court and High Court, right? But legal rights, they are enforceable through ordinary courts. So it could be ordinary courts such as the district court, or even the village council, the Topashi court, in the DC office. Any ordinary court ho jayega for the enforcement of any form of legal rights. But for fundamental rights, directly enforceable by the Supreme Court and the High Court. Okay? And fundamental rights is difficult to amend, and that explanation is easy to understand. Amend means make changes. We talked about the special majority. But legal rights, they can be easily amended. Fundamental rights are protected by the Constitution. Legal rights, they are protected by statutes, which means, for example, India Modi government as they enact a law, okay, by statute. A statute is any kind of law passed by the Indian Parliament. Okay, it's any kind of law passed by the Indian Parliament. So, if BJP government ba ekta create krushe, law ekta create krushe, next time Congress aram di uta khatai diwo. Na statutes can do, it keeps on changing. But fundamental rights, it stays forever. Doesn't matter the change in the government, doesn't matter the change in the ruling party, anything. Fundamental rights, they remain the same. Okay? So, fundamental rights, Supreme Court under Article 32, whereas for legal rights, ordinary legal remedies. Now, I hope that the distinction between fundamental rights and legal rights is very clear. Legal rights are those rights that are recognized by the Indian Constitution, but they are not fundamental rights. So anything outside of fundamental rights is legal rights. Okay? Now, hierarchy of rights in India. I created this tree. I created this hierarchy for better understanding of the kind of rights that we're talking about. Okay? In the hierarchy of rights, we can see that there's natural right. Right? Natural right is always at the top of every other right. In this entire world, there's one right that's above everything, that's natural right. That is natural right. So in the natural rights, it automatically is inside us. We do not have to create it. Okay? By virtue of being a human being itself, you got your natural right. Okay? We have our moral and philosophical rights. Okay? And these natural rights, they inspired modern constitution. Okay? So every right that we enjoy now is derived from the Indian Constitution. So the main is the constitutional rights. Okay? Constitutional rights. So we have the constitutional rights, rights guaranteed by the Indian Constitution. It's a higher source of legal protection. Okay? Or legal protection or legal validity. Now in that constitutional right, there are lots of other rights. Right to property is an ordinary legal right under Article 300A of the Indian Constitution, right? So there are rights other than fundamental rights. Okay, so in the Constitution, the fundamental rights, Article 12 to 15, the fundamental rights are fundamental rights, but the other rights in the Indian Constitution are constitutional rights. Okay, constitutional rights. Any right mentioned in the Indian Constitution other than fundamental rights are called constitutional rights. Is that clear? Now, there's another type that is not mentioned in the Indian Constitution, that is not explicitly mentioned in the Indian Constitution, but the Indian Parliament, they create these rights using the powers given to them by the Indian Constitution. These are called statutory legal rights. Rights that are not mentioned in the Indian Constitution directly, but rights created by the powers given to them by the Indian Constitution. Now, if you look at Part 11 of the Indian Constitution, you will learn about the relations between the union and states, and then the state list, the union list, in a divide Kurnas day. So union, they have the power to make laws related to subjects mentioned in the union list. For example, the union list has railways, defense. Okay, so defense la kiki laws panai utan sopi statutes kana sudo. They are not mentioned in the Constitution, but Part 11 of the Indian Constitution gave the government the right to, the union government the right to make laws for the defense, for the railways. So whatever rights we have in relation to Indian railways, these are all statutory legal rights, which is not. So in the Indian Constitution, rights to that type thagibo, directly mentioned fundamental rights and then constitutional rights. Aro fundamental rights mention kurigina nai, but fundamental rights la power luigina rights can ki create kure utan sopi statutory legal rights ache. This distinction you are going to need it for the entire journey. Okay, so it's very important that you get it right this time. Itu genuine like statutory. What are statutory bodies? Constitutional bodies? I confusing as well. We're not talking about. So yedira bishi balo buji jay. Okay. Now again, positive versus negative right. Fundamental rights, there are certain rights that are positive, there are certain rights that are negative. Okay. So if you look at it, negative rights, state can get interfere no guru kwase, which means it protects us from the state. But positive rights means the state should protect us. Very easy distinction. Now if you look at negative rights, it requires the state not to interfere. The example could be Article 19, freedom of speech and expression, freedom of movement, personal liberty, which is in Article 21. Personal liberty, life and freedom of life and personal liberty is mentioned in Article 21. These are examples of negative rights, which means it requires the state not to interfere. We have the right to do this and that, and the state cannot stop us. Whereas for positive rights, the state can get state can get to take action. Right to education, Article 21A, right? And whereas other reservations for ST, OBC, and so forth, reservation can be state ke koise. And then legal aid, there's a term called eminence curiae. Okay, supposing you're very poor, you do not have the financial power to hire a lawyer, the court will hire it for you, and that is called eminence curiae. It's a Latin term which translates to friend of the court. So the government should also provide legal aid to the public whenever the public is unable to do so. So whatever it may be, positive right means state can get quasi, negative means mon get quasi, or it protects us from the state. Okay. Negative rights do not interfere. My life, my rules. Negative right does them. And positive right means please help us type ekta. State can get. State, when you're in need of help, the state should take action. Now let us dig deep into fundamental rights. Okay, we'll start with 14 all the way till Article 32. Let's begin with Article 14, right to equality. We will discuss every article one by one. Fundamental rights is very, very important. We just have a 1 minute break. Does anyone want to drink water? Okay. So, right to equality, okay? This is the first fundamental right to equality. Article 14, there's equality before law and equal protection of laws. Okay, it simply means everyone is equal before the law. You or me or the Prime Minister of India, the Governor of Nagaland, everyone is equal before the law, and everyone will be protected by law equally. And in Article 15, prohibition of discrimination. No one should be discriminated on grounds of religion, race, caste, sex, or place of birth. Which means it doesn't matter your religion, your race, your caste, your sex, or your place of birth. Everyone is treated equally. Now let me ask you a question. Now, everyone must be treated equally based on Article 15, right? Every race, every religion, every caste, every sex must be treated equally. Now, why do we have special reservations for women? Why do we have special reservations for SC, ST? That's discriminatory in nature, to be honest. That's discrimination, right? Discrimination. Choosing one over the other. That's discrimination. Okay. Now, is this discriminatory reservation? Because Article 15 states that we should not discriminate on grounds of religion, but we do have some benefits for the Christians because we're minorities, race, and caste, SC, ST, OPC, reservation, alag-alag de. Sex, females kangyaro. There was a lot of talk about the 33% women reservation in state legislative assembly as well as Indian parliament, and our place of birth as well, where you're born. If you're born in Nagaland, if you're born in Assam. So, isn't it discriminatory reservation? Okay. But we will learn. The reason why I'm asking you this is because, again, the Indian Constitution states that the Parliament has certain powers to make reservation. Okay. It will be power diginas, and I will explain to you why. Why is it discriminatory, but it is necessary? Okay. So you have understood Article 16. There's equality of opportunity in matters of public employment. Again, we also have reservation there. We have reservation in Nagaland as well as we have reservation in UPSC. We have reservation for ST, right? Almost, I think everyone in the history of Nagaland, the highest rank was Richard Jantan, 130 something, right? I think he got IS in the year 2021. So we Nagas, we didn't get rank. We didn't get UPSC rank higher than 130 something. So which means everyone comes under reservation, ST reservation. All the Nagas that have ever been IS officers, IPS, IFS. So we also have reservation, both in the center as well as in the state. But here it says equality of opportunity in matters of public employment. We'll also discuss about that. And Article 17, abolition of untouchability and prohibition of this practice. Okay, untouchability, we discuss about that. Article 18, abolition of titles. Okay, the great Maharaja, Bharata, this and that, they had a lot of titles during the commencement of the Indian Constitution. All these were abolished. You cannot use those titles, except military and academic, which means general, major, captain, or academic means professor, doctor, and so forth, engineer. Now, let's look at Article 14, equality before law and equal protection of laws. It's available to everyone, not just Indian citizens. I mentioned that the articles available to only the Indian citizens are Article 15, Article 16, and can you guys remember? Article 19, Article 29, and Article 30. So this Article 14 is available to all persons, not just Indian citizens, and it's a foundation of the rule of law. Rule of law means everyone must abide by the rule mentioned in the law. Okay? It prohibits state action, ensures fairness and non-discrimination and so forth. You guys can understand that. I don't need to explain that. Now, equality before law and equal protection of law, which means everyone is equal before law and everyone will be protected by law. So these two concepts are under uh, Article 14. Okay. Now, equality before law is British origin. You might be asked that. Okay. And equal protection of laws, American origin. You can see that equality before law is a negative concept. Equal protection of laws, positive concept. Which means equality before law means it protects us from the state, right? That in case you do something, or for the entire community, the law is the same. But here, equal protection of laws, which means the state is required to protect you. Okay, equally. That is a positive concept. And no person is above law. Equality before law means no person is above law. And equal protection of laws means equal treatment in similar circumstances. Okay. Now, I think it's clear. Equality before law and equal protection of laws. And exceptions to Article 14. Now, Article 14 says that everyone is equal before the law and everyone should be equally protected by the law. But there are certain exceptions, okay? Foreign diplomats, for example, if you are a US citizen and you're working in the US embassy in India, let's say you're working in US embassy in India, you're residing in India, you're a foreign diplomat, right? Or let's say you are an official sent by the President of US, Donald Trump. Donald Trump sends one of his associates to India to sign a peace treaty or something. He is considered a diplomat. And let's say he comes to India and then he is accused of raping someone in Delhi. Okay. So our laws don't apply to him. Diplomats are diplomats. In India will respect diplomats of other countries, and other countries will respect diplomats of India. Which is to say, if a US diplomat commits a crime in India, he will be extradited back to US and the US will deal with him, not us. And if you're an Indian and you go to China, you go to US and you commit a crime, the punishment will be given to you by the Indian government. You will be extradited back to your home country and you will be dealt with in accordance with the laws of your country. And there are certain foreign diplomats that belong to, let's say, UN, United Nations, okay? And these are international organizations, not specific to a particular country. So if he commits a crime, then he may be dealt with by the United Nations. But this agreement is discussed between home country and the international organization. But whatever may be the case, we do not have the right to judge the wrongdoings of diplomats coming to India. And even towards the President of India, during his term, okay, only during his term, during a 6-year term, 5-year term, he cannot be processed, okay. Whatever needs to be processed can be processed after he ends his presidentship. The same with the governor, okay. So these are some restrictions, some exceptions to Article 14, but that's understandable, right? Which of the following are exceptions to Article 14? If they ask you a question in the exam, the answer is foreign diplomats, President of India, the governor, and so forth. Now, let's move on to Article 15, prohibition of discrimination. Article 15, prohibition of discrimination. Now, there's a lot of discrimination in the Indian society. Okay, there are lots of discrimination in the Indian society. Since we're in Nagaland, we are not aware of it too much, because in the Naga society, discrimination is like something that's unheard of, right? Discrimination. I mean, we do it ideologically, but for them, it's a direct discrimination. Whatever may be the case, direct or indirect, it talks about prohibition of discrimination on grounds of religion, race, caste, sex, place of birth, or any of these grounds. It applies only to Indian citizens, okay? Discrimination, prohibition of discrimination applies only to Indian citizens. Now, here is the exception that I talked about earlier. Reservation, okay? There are some exceptions. The state may make special provisions for women and children, socially and educationally backward classes, which means the SC, the ST, and economically weaker sections. These are powers granted to the Indian Parliament, okay, to make laws for reservation. So that is why we have the reservation. Even though everyone's treated equally in a society, to uplift the economically weaker sections, to maintain economic equality, because every revolution that we see around the world, its root cause is economic crisis. Okay, economy. So if we leave one section of the society very below and the other section of the society rises and there's great disparity, revolution is inevitable, and revolution causes instability in the country. It causes chaos, right? So they're trying to make sure that the weaker sections of the society are upgraded, and for them reservation becomes necessary, and which is why they have reservation. There are lots of the 93rd Constitutional Amendment Act provided reservation in educational institutions, and 103rd Constitutional Amendment Act provided 10% reservation to economically weaker sections. Reservations are constitutional exceptions, not violations of equality. If you write in the mains examination that reservation is discriminatory in nature, you will not get marks. Okay, you have to write that these are constitutional exceptions, not violations of equality. We all have opinions, but we have to leave it aside and say that it's a constitutional exception, not violation of equality. Now, Article 16. Even here, we will also learn about reservation. Now, equality of opportunity in matters of public employment. Here are the key points. Equal opportunity in government employment. No discrimination on prohibited grounds. Merit remains important. Meritocracy. Reservation goes against meritocracy, right? It goes against meritocracy. In an ideal society, there should be no reservation. I think everyone will agree with that. No, because everything should be chosen on the basis of merit. Now, reservation, but here again, reservation in matters of public employment is permitted under specific constitutional provisions. Now, remember, Article 16 balances equality with social justice. What is social justice? Yes, equality thaigo lage, but society to be justice ho lage, which is why reservation anishe. Okay. Now, reservations under Article 16. There are reservations with regard to equality of opportunity. There are reservations for backward classes. They also guarantee adequate representation, and reservation in promotion is also in existence, and these are constitutional safeguards. Now, in Mandal Commission case, Indra Soni, it's a very interesting case, which broadened the meaning of article, which upheld the provision under Article 16.4. Article 16.4 of the Indian Constitution, it empowers the state to create reservation. Okay, Article 16.4. What is Article 16? Equality of opportunity in matters of public employment. And under that, there's a clause, Article 16.4, under Article 16, which empowers the state, India, to create reservation for backward classes. Okay, so in the Indira Soni, Mandal Commission Indira Soni case, now reservation for ST and SC, we have always had it since the commencement of the Indian Constitution. In 1950, we have always had reservation for SC and ST, but for OBC, other backward castes, it was recommended by Mandal Commission, okay, which was in the year 1979, and it identified other backward class, OBC, as socially and educationally backward, and it recommended that they be given 27% reservation, and the Supreme Court accepted it. Okay, Supreme Court accepted it, and it gave 27% reservation to OBC. We already had reservation for SC and ST. Never forget that it was at the time of the commencement of the Indian Constitution that we got the reservation. But for OBC, it was a result of Mandal Commission. Okay, Mandal Commission, but the people went against it. It led to widespread protests and legal challenges. Now, the matter was decided by the Supreme Court in a case called Indra Sawhney versus Union of India case in 1992. Okay, in 1992, like I said, the Mandal Commission identified OBC as a backward class in 1979. And even though the Supreme Court tried to implement it, people were against it. And the final decision was made in 1992 in the Indra Sawhney case. Okay, so, and the Supreme Court upheld the validity of Article 16.4. Article 16.4, it says that yes, reservation is right. And 27% reservation for OBC is right. So these are Article 16.4, which talks about reservation quotas. It was upheld, finalized in the 1992 Indra Sawhney case. Okay. Indra Sawhney case. Now, creamy layer. In the Indra Sawhney case, it also introduced the concept of creamy layer. Creamy layer, which means a creamy layer is a layer created by the Indian government to decide who should get the reservation and who should not get the reservation on the basis of his economic status or financial status. Okay, that's creamy layer. Now, creamy layer is only for OBC, not for SC and ST. The government felt that ever since the reservation for OBC was implemented from 1992, there were lots of rich OBC families who took advantage of the reservation, and which is why they decided to introduce the creamy layer. And under the creamy layer, there are different categories: high income OBC families, constitutional post holders, any post, any government post, and senior defense officers, Group A and B officers, professionals like doctors, engineers, and so forth, and other advanced sections. These come under the category of creamy layer. And these people, creamy layer, does not receive OBC reservation benefits. And there are arguments even today to apply the same creamy layer to SC as well as ST. Next, we have Article 17 to Article 18. Social equality. Now, Article 17 and Article 18, it's still under right to equality, okay? Abolition of untouchability. Its practice is prohibited, it is punishable by law, it is enforced through the Protection of Civil Rights Act 1955. Okay, the rules for untouchability is mentioned in Protection of Civil Rights Act 1955. And Article 17, as I mentioned, is an absolute fundamental right. Okay, absolute fundamental right. And Article 18, abolition of titles. I talked about the Maharaja and so forth, the different titles that were abolished by the Indian Constitution. No hereditary titles. Everything has been abolished, but military and academic distinctions permitted, like doctor, professor, and so forth, and national awards like Bharat Ratna, Bharat Vibhushan, Padma Shri, and so forth. These are valid, but they cannot be used as prefixes or suffixes, which means you cannot add that in your name as a title. Okay, Padma Shri, Mr. So and so, you cannot do that. Okay, so that's what it means by cannot be used as prefixes or suffixes. Now, another very not too important but a necessary one to understand is people were against national awards. A lot of people were against national awards, but it was in the case of Balaji Raghavan versus Union of India 1996 that the Supreme Court again supported the constitutional validity of national awards. Now next we have right to freedom. Okay, next we have right to freedom. These are the articles covered: Article 19, 20, 21, 21A, Article 22. Please read Article 19, 20, 21, 21A, and 22 from the document given to you. Article 19, we have protection of 6 rights regarding our freedom of speech, our freedom to assemble, our freedom to form associations, our freedom to form movements, our freedom to recite, our freedom to be in any profession. That's Article 19. In Article 20, in respect of conviction for offenses, if we're arrested, we have certain protection, okay? Article 20. In Article 21, we have the right to life and personal liberty. And in Article 21A, we have the right to education. Article 22, we have protection against arrest and detention. If you're arrested, if you're detained, in certain cases, you have protection. So we will discuss on that one by one. Now, Article 19. The first is 19. The freedom of speech and expression. Please take a look at the presentation. We have the freedom of speech and expression. We have peaceful assembly. We have freedom to form associations or cooperative societies. We have freedom of movement, freedom of residence, freedom of profession, occupation, trade, or business. So which means your decision to be a civil service aspirant is the right guaranteed to you under Article 19. Okay? Freedom of profession. Or if you wish to be a nurse, if you wish to be a doctor, whatever it may be, you also have the freedom to choose that. That's the freedom given to you by Article 19. Now, in freedom of speech and expression, you have to remember one very important point. Freedom of the press. Okay, the press. News channel can. It's not separately mentioned it is in the Constitution, but it is derived from Article 19.1a. 19.1a means freedom of speech and expression. Also includes freedom of the press. Okay, so these are the key points. It includes the right to express opinions freely. It covers verbal, written, printed, artistic, and digital expressions. It includes freedom of the press, subject to reasonable restrictions. Like I said, at times of national emergency, it can be suspended. The remaining 5 freedoms, you can take a look at it once you're home. Now, there are reasonable restrictions. We have already discussed on that under Article 19. For the security of the state, there are restrictions. Rights exist alongside responsibilities, and we always have to understand that whatever we have rights, we are also responsible. Now, in Article 20, protection in respect of conviction for offenses. So, if you are convicted of a crime, okay, 3 rights are provided to you by Article 20. No ex post facto law, which means a person cannot be punished under a law that did not exist when the act was committed. For example, if you committed a theft, okay, if you stole a bike, and if the law says that the punishment for stealing a bike is 2 years, but the moment that you were arrested, 2 days later, while you were still under police custody, while you were still detained under detention, law changed. And now the new rule says that punishment is 10 years for stealing a bike. But when you committed the crime, the punishment was 2 years. So only 2 years will be applied to you. That's what it means by no ex post facto law. There will be no post after law applied to you. So a person cannot be punished under a law that did not exist when the act was committed. Okay, 10 years did not exist when you committed the act, so 10 years won't apply. 2 years was the rule when you committed the crime. Okay, so 2 years will apply. And no double jeopardy. No person shall be persecuted and punished twice for the same offense, which means after you serve your 2-year term in jail, you come out and then you're sent back again to serve twice. You cannot be sent twice. No double jeopardy. Okay, you cannot be jeopardized twice. Now that's another right given to you when you're arrested. And no self-incrimination. And accused, which means you cannot be compelled to testify against himself or herself. Which means sometimes it can happen that someone can force you to testify against yourself. You are committed of, let's say, stealing a bike, but you did not steal. Okay, you did not steal. Let's say you did not steal. But there's someone who is against you. Let's say a government official, someone who is very powerful, the police, it forces you to testify against yourself, to tell by yourself that moi chor kurse. Okay, you cannot testify against yourself. It protects you against self-incrimination. Sometimes kunba do tukya manu thake do jail de thuri ka do aru tange force kori do nijor gobi nijor korise guna to protect against forceful self-incriminatory remarks. Okay, to tukya manu ekta ge protect koro karone no self-incrimination la rule do clause 8 korise. You cannot be forced to testify against yourself. That's the meaning of no self-incrimination. No ex post facto law, no double jeopardy, no self-incrimination. These are the three protection provided to you under Article 20 when you are convicted for offense. Is that clear? Now in Article 21 is very vast. Okay, protection of life and personal liberty. It's available to every citizen. It's one of the broadest fundamental rights. It expanded significantly through judicial interpretation, and it protects dignity, liberty, and quality of life. Article 21 is often called the foundation stone of Part 3. Now, take a look at the quotation. No person shall be deprived of his life or personal liberty according to procedure, except according to procedure established by law. Which means you cannot be deprived of your life. But, now just imagine that you killed hundreds of people with a gun as an act of vengeance for a society that has tortured you, let's say, and you kill hundreds of people, and the court can take away your life. Okay, the court can issue an order directing that you be given life sentence, or let's say capital punishment. You'll be hanged. So the court can take away your life, your personal liberty under special circumstances. Okay, you should always remember that. You cannot just think that like ki kuro but kunmi moyo morana pro. The court can still issue a capital punishment against you, which is why it's mentioned except according to procedure established by law. The evolution of Article 21. 1950, we had a very narrow, very small interpretation of Article 21, which means protection of life and personal liberty. But over time, in 1978, Manika Gandhi versus Union of India. Now, let me just give you a brief explanation about Manika Gandhi versus Union of India case. What happened was, Manika Gandhi do Mahatma Gandhi la cousin sister no ide. It's just her name is Gandhi. Manika Gandhi was a journalist. She received her Indian passport to travel abroad. Okay, and a year later, she received her Indian passport, I think in the year 1976. And in the year 1977, the regional passport officer ordered Manika Gandhi to submit her Indian passport to him. Okay, which means seize Indian passport. Now Manika Gandhi said, why are you seizing my Indian passport? Give reasons in a letter lecture, but then the regional passport officer, he sent back the letter, said that it is not in the interest of the public to give reply to you. Something along that line. So Manika Gandhi, she went to the Supreme Court, right? She went to the court to enforce fundamental right, to enforce Article 21, saying that it's part of his freedom of life and personal liberty, that she can, it's part of his life to go abroad, it's part of his life and personal liberty, freedom of life and personal liberty to go abroad. Okay. So the court issued the final judgment in the Manika Gandhi versus Union of India case, in which the court agreed with Manika Gandhi, saying that even the right to go abroad is also part of Article 21. Okay, part of Article 21. So Article 21 the basic basis, and it also in the Manika Gandhi case, the court also introduced the golden triangle, which means just, fair, and reasonable. Whatever judgments, whatever decision made by the government, it should be just, fair, and reasonable. Okay. Now, these are the rights. See, different rights, right? In Article 21, it's just mentioned the right to protection of life and personal liberty. But Even the right to travel abroad is a part of personal liberty. Okay. Right to live with dignity, right to livelihood, right to privacy. Your right to privacy comes under Article 21. So, beshi par ICU, almost every year they'll just give a random right to so and so. It comes under which article? Usually it's Article 21. Okay. Article 21 is very vast, but they are not mentioned in the Indian Constitution. But different Supreme Court judgments have made declarations that right to go abroad is part of Article 21, right to privacy, right to shelter, right to health, and so forth. So you need to memorize all that. This all come under Article 21. So you didn't learn that right during your college days, but now you have to. Okay. Article 21A, right to education, very brief, inserted by the 86th Constitutional Amendment Act of 2002. There was no Article 21A before 2002, okay? It was inserted by the 86th Amendment, Constitutional Amendment Act 2002. It says that the state shall provide free and compulsory education for children aged 6 to 14 years. Very simple. We don't need to discuss on that. That's right to education. Now, Article 22, protection against arrest and detention. Now, this is a little bit complicated, but please try to pay attention. Protection against arrest and detention. Detention means preventive detention. Now, when we're talking about arrest and detention, arrest means you are arrested for a crime that you have already committed. Okay? Preventive detention means they arrest you before you commit the crime because they think that you will commit the crime. Arrest is preventive detention, which means to prevent you from committing a crime. So there are two rules for both arrest as well as preventive detention. Okay, so again, this is a fundamental right. This is a fundamental right for arrest as well as preventive detention. Now, if you are arrested for a crime that you have committed or may not have committed, but you were arrested, okay, you have the right to be informed why you were arrested on the grounds of arrested. You have the right to consult a lawyer and also be defended by a lawyer. You must be produced before a magistrate, before the court within 24 hours, which means you cannot be tortured inside a jail for 2-3 days. You must be produced before the magistrate within 24 hours. Okay, and then if you were to continue being inside the jail, if your detention were to continue, which means inside the jail for more than 24 hours, court la magistrate la signature like you will. Is that clear? So these are protections given to you in case you were arrested by the police. You have the right to say to the police, I have the right to know why I was arrested. Okay? And you cannot keep me inside the jail for more than 24 hours. And if you decide to keep me inside the jail for more than 24 hours, please accord a signature from the magistrate and show it to me. You can say that to the police officer. Okay? You have the right to know why you were arrested. And you can also say, I have the right to be defended by a lawyer. You can say those things. And in the in preventive detention, which means you were arrested because they suspected that you might commit a crime. Sometimes it happens. Terrorists, undergrounds can't take it. They receive a tip and then they go and they arrest the undergrounds before they commit a crime. It's happened so many times. So in the case of preventive detention, but it doesn't apply to underground, okay? These are outlaws, right? But it applies to us citizens in case we are detained, okay, as a form of preventive measure. If we are detained, we did not commit a crime, but the government thinks we might commit a crime, so they arrest us. You have the right. Again, it does not apply to enemy aliens, which means these rights, the above rights, it doesn't apply to enemy aliens, which means foreigners, and preventive detainees. So for preventive detainees, we have Article 22, 4, 5, 6, 7. Detention beyond 3 months require advisory board's approval. So if you're detained as a preventive measure, right, you do not have too much right, okay? You do not have too much rights, but if you are detained beyond 3 months, they will form an advisory board to approve your continuance in the jail. And you also have the right to know the grounds of detention and make a representation, which means it's the same as the above. You have the right to know why you were arrested, and you also have the right to appoint a lawyer. Facts may be withheld if disclosure is against public interest, which means facts may be withheld. Facts about your detention may be kept secret. Okay, if disclosing it is against public interest, and the parliament decides the maximum period and procedure for preventive detention. So the parliament, they make rules for preventive detention. Okay, now is that clear for preventive detention? Now let's move on to ordinary arrest and preventive detention. Ordinary arrest and preventive detention. Now, when it comes to ordinary arrest, it's based on a committed offense, and preventive detention to prevent a possible future offense. I think I've discussed on that earlier, so I will skip that. Now, right to freedom, Articles 19 to 22, quick revision. Article 19, 6 fundamental freedoms. Article 20, the 3 criminal law protections. We have no ex post facto, no double jeopardy, and no self-incrimination, right? And Article 21, we talked about life and personal liberty and how vast it is. Article 21A, it was introduced by the 86th Amendment of 2002, which provided free and compulsory education to children between 6 to 14 years of age. And Article 22, protection against arrest and detention. Arrest being you're arrested for a crime, and detention means you are arrested to prevent from committing a crime. Now let's move on to Articles 23 and 24, right against exploitation. Article 23 and 24, right against exploitation. Article 23, prohibition of traffic in human beings and forced labor. Article 24, protection of child labor. Prohibition of child labor, sorry. So these are the 4 articles, these are the 2 articles, Article 23 and 24. Article 23, prohibition of traffic in human beings and forced labor. Okay, now what is forced labor? Can anyone answer me? Forced labor means it's a kind of modern slavery where a person is forced to work, right? And sometimes it can be unpaid, and even if it's paid, it's below the minimum wage. So that's forced labor. So it prohibits, the Indian Constitution, the fundamental rights prohibits forced labor. And it also prohibits trafficking in human beings. Human trafficking, you know that, right? Trafficking of humans and so forth. Okay, it applies to citizens as well as non-citizens. It's enforceable against both the state and private individuals, meaning anyone who traffics human beings will be dealt with by the law. Now, payment below the statutory minimum wage may amount to forced labor under Article 22. Now, the central government, it says a national floor level minimum wage of, I think, 178 rupees per day. 178 rupees per day, which means the state, every state has the power to set minimum wage, but they cannot set minimum wage below 178 rupees per day. Okay, so no state is legally allowed to fix the amount less than 178, lower than this baseline. And understanding human trafficking, forced labor is also trafficking, bonded labor, sexual exploitation, child trafficking, slavery, sale and purchase of persons. Okay. Article 24, prohibition of child labor. So it prohibits employment of children below 14 years. Okay, very important. Remember, below 14 years in factories, mines, hazardous occupations, and hazardous processes. Okay, its objective is to protect children's health, safety, education, and childhood. This is an absolute fundamental right. Now, child labor laws. 1950, it only had the fundamental rights. And in 1986, it had the Child Labor Prohibition and Regulation Act. And in 2006, the Domestic Work and Hotels Prohibited. So, domestic work, what do we mean by domestic work here? When it comes in relation to child labor. Domestic work meaning, mon nijor lagorde kam granoi. Alang manu lagorde na. China kam gurle, pachakan ge alone gurle. Fundamental rights is something, which is why be very careful when you employ people in your house khandan manu khan ge education gan bhalwa digina ni body as ekta khata you let them go to school come back but then khali kam korele ekla bacha kan rakha do it is not right. We also have to educate our parents that below 14 years of age korde narakhiwa lagi okay baragan narakhai bhala ase after 14 or ideally 16 and above na bacha ase 14 to 16 be so we have to make sure 2016 Amendment 8 and Amendment 8, employment below 14 years prohibited in all occupations, subject to limited exceptions. What are the exceptions? For example, if you're a child artist, okay, let's say you are 13 years of age, but you know how to pen so beautifully, and you're earning through that. So this is an exception, because he is not being forced. Actually, in fact, like the government encourages that. So these are some exceptions, okay. But other than that, we should not be forced again, huh? So don't say. Now, right against exploitation. Right against exploitation, chapter summary. Understandable. Freedom of religion. Every person enjoys the freedom of conscience and the freedom to profess, practice, and propagate religion, subject to constitutional limitations. Okay. In the freedom of religion, we have Articles 25, 26, 27, and 28. I'll just be very brief. We'll just have another 10 to 15 minutes. Don't worry. In Article 15, guarantees freedom of conscience, freedom to profess religion, freedom to practice religion, and freedom to propagate religion. Now, Article 25, you have the freedom of conscience to choose a religion, okay? And you have the freedom to profess your religion, practice and propagate your religion. That's it, very simple, Article 25. Article 26. Now in Article 25, please take a look at the projector. Does Article 25 include a fundamental right to convert another person? There's a lot of issue has been pointed out about forced conversion, right? So Article 25 doesn't give you the right to convert another person by force, okay? It doesn't give you the right to convert another person by force. The principle is that propagation is permitted. You have the right to propagate Christianity, to spread Christianity, but you do not have the right to convert a person by force, okay? That's a very important distinction. Now Article 26, you have the freedom to manage religious affairs. Manage means you can establish religious institutions, you can maintain charitable institutions, you can manage religious affairs, and so forth. Now, Article 27, freedom from payment, freedom as to payment of taxes for promotion of any particular religion, which means all the church institutions that we have here in Nagaland, they do not pay taxes, okay? They do not pay taxes. Everyone is free from payment of taxes for the promotion and propagation of religion. Now, Article 28, religious instruction in educational institutions. Now, there are different types of institution. If it's fully owned by the state, which means government high school or government higher secondary school, religious instruction is not allowed. Okay, not allowed. So, if it's state recognized, like let's say Unity College and Imano College, so it's permitted. Okay, if the Unity College wants to have an evangelical union, they can have, but its attendance to attend that union, it is not compulsory. Okay, now state aided, if it is state funded, if it is funded by the state, some institutions are funded by the state, partly funded by the state. An example would be, let's say Patkai Christian College. They can introduce religious instruction, but again, attendance is not compulsory. Okay, so it's state administered under religious endowment, which means under religious endowment, a Muslim organization requested for a Muslim school to be built for Muslim students, and the state funds that institution. They're allowed, they're permitted to have religious instructions. Okay, these are the key differences between different institutions. Now, quick revision, we'll skip that. Cultural and educational rights. We have Article 29, we have Article 30. Article 29, protection of interests of minorities. So we are minorities, right? We are Christian minorities. We are Christian minorities as well as ST minorities, as well as the ST minorities were tribals. Okay, so in Article 29, the Indian government through the fundamental rights states that we have the right to protect our language, our script, and our culture. Whatever culture we have here in Nagaland, everything is protected by Article 29. Okay, we have our distinct language, script, or culture. We have the right to conserve and preserve cultural identity. Now, Article 30. As a minority, we also have the right to establish and administer educational institutions. Okay. Key points available to all religious and linguistic minorities. If we set up Catholic schools here, right, a minority Catholic school here, we have the freedom to do so under Article 30. Okay. So, rights of minorities establish and administer educational institutions. Very easy to understand. So, quick revision, we'll skip that. This is a final right to constitutional remedies. Now, it's very important for you guys. It'll just take 5 to 10 minutes. Please listen to it very sincerely. It's very important. Right to constitutional remedies. Okay, it is the right that protects all the other fundamental rights. Now we discuss about the different fundamental rights from Article 14 to Article 30. Right? You have the different fundamental rights. Now, if any of your fundamental right is violated, the right to equality, right to freedom of religion, right against exploitation, cultural and educational rights, if any of these rights have been violated by anyone, be it the state, be it the individual, if they violate your right, Article 32, okay, will protect you, which means Article 32 gives power to the Supreme Court to issue an order to protect your fundamental rights. Okay, to punish the person who has violated your fundamental rights. So it is right to constitutional remedies that protects all your fundamental rights. Without Article 32, there's no point in having fundamental rights, right? Because who will protect the fundamental rights if there's no protective mechanism? What's the point of fundamental rights? So this Article 32 protects your fundamental rights. Okay, so what's the process? Violation of fundamental rights, your right is violated. You as a citizen, you approach the court. The Supreme Court will issue writs. The court issue writs. Writ means an order issued by the court to someone to do this or not to do that. Okay, it's simply an order issued by the court. Writs are simply order issued by the court, and then the court will issue writs and fundamental rights will be enforced. That's the basic procedure. Without Article 32, fundamental rights would become ineffective. Now, these are the 5 ways in which you can approach the court, or these are the 5 writs. These are the 5 writs that the 5 orders that the court can issue, okay, for violation of fundamental rights. We will learn about that one by one. Now, habeas corpus. If you take a look at habeas corpus, it means to produce the body of, or to have the body of. So let's just take the example of, for example, you were arrested. Okay, let's take the example of you being arrested. You were arrested. Now, if you were arrested, you were not given the reason why you were arrested. You can go to the court, okay, and invoke the writ of habeas corpus. Habeas corpus means anyone who arrests you should produce you before the court. Right, we talked about that. 24 hours, within 24 hours, they cannot just keep you in jail for a very long time. They must produce you before the court and just also give reasons why you were arrested. Okay, so which means it protects you from kushi-mushi arrest and detention, habeas corpus. Okay, to have to produce the body, which means to produce you before the court. Which means as long as you are near the court, you are protected. That's what the court is trying to say, right? If the authorities, they arrest a person Kushi ushi tai jail de like months and months rakhiona pare. They need to be produced before the court, and they also need to give reasons why that person was arrested. So for unlawful arrest and detention, habeas corpus protects us. No mandamus. No mandamus, for example, you go to TC office and then birth certificate garni apply kushe. Okay. So birth certificate TC office par diya nai. To yete mandamus apply kurbo, which means we command. It compels performance of a public duty. Tala duty asudo to give you. To court par kobo to perform your duty. You must perform your duty. Why are you not giving him the birth certificate? Why are you not giving her the birth certificate? Perform your duty. So if you go to a government office and they do not do the duty, they do not give you what you asked for, you can go to the Supreme Court and argue against it using mandamus. Okay, very easy to understand. And what's next? Prohibition and certiorari. Now, prohibition and certiorari. Please take a look at prohibition and certiorari. Prohibition means preventive, and certiorari means corrective. Now, prohibition simply means it is to stop a lower court from exceeding its jurisdiction. For example, administrative district court to deal with administrative issues. Now that administrative court, if he takes up the issue of murder case, he's not allowed to do so. He's exceeding his jurisdiction. So court can be, it is issued to a court, okay? Prohibition. It prohibits lower courts from exceeding its jurisdiction. So administrative court, high court par kobo, why are you exceeding your jurisdiction? Your only job is to handle administrative cases, but you are handling a murder case which you shouldn't. So you are exceeding your jurisdiction, therefore do not exceed your jurisdiction. That's prohibition. And certiorari means if you were arrested, okay, let's say if you were arrested because you killed someone, allegedly, you did not kill but you killed, and then the sessions judge, district judge, issued a capital punishment. But abni do manugi moranai do, live it capital punishment. So high court, if the high court finds that there's no proper evidence, then the high court will cancel the order of the district court. That's certiorari, to be certified. Certiorari simply means that there will always be the Supreme Court and the High Court to protect us against the kushimushi judgments of the lower court. Okay, that's the benefit from certiorari. And quo warranto. Quo warranto means quo warranto means by what warrant or authority. It questions the legality of a person's claim to a public office, which means, example, so a person becomes a university vice chancellor without proper qualifications. Let's say, backdoor appointment by JCA. He's just a mere graduate, but to be a university vice chancellor, you need to have a PhD degree. But he becomes a university vice chancellor, so we can take the matter up to the court, and then the court will decide, will issue a writ, a quo warranto writ, questioning that person by what warrant, by what authority did you are you holding this post? Okay, so it is quo warranto will protect us against illegal or unfair holding of government posts and offices. Okay, so quo warranto, a person becomes a university vice chancellor, the court will say, by what warrant or authority are you here? Okay, what is your qualification? What is your, which exam did you get through? These things will be asked by the court. So these are the 5 ways in which the court will protect us. First, habeas corpus, right? Whenever we're arrested, the court will release us if we have been unlawfully detained, and we have the mandamus, right? Mandamus, and then mandamus will order a public authority to perform its legal duty, like I gave you the example of TC office. And then prohibition stops a lower court from exceeding its jurisdiction. I gave you the example of the district judge, administrative court dealing with murder case. That's beyond his jurisdiction. And certiorari, we talked about, I gave you guys the example of a sessions court giving you capital punishment. And quo warranto, vice chancellor like example dishes. So these are the ways in which the government protects us. Okay. Now, these are the landmark constitutional cases that you can refer to once you go back home. And these are the important amendments. And these are the frequently confused concepts that you can go back home and that you can compare and contrast. And this is the prelims revision. Most asked questions. You should know Article 12, 13, 14 to 18, 19, 21, 32. You have to know the 5 writs. You have to know the important cases. You have to know the constitutional amendments. You have to know the reservation. You have to know the emergency provisions. Okay, and these are the main practice questions. You can also try practicing it. So thank you. Any questions and discussion?